Permanent mission of India to the United Nations versus City of New York.
The permanent missions of India and Mongolia to the United Nations own property in New York City to house low-level diplomats. Under New York City law, real property owned by a foreign government is exempt from taxation as long as it's being used exclusively to house diplomatic officials who hold sovereign authority in the United Nations. As such, these low-level diplomats did not meet these requirements, and the City of New York began to levy taxes against the properties in question.
The governments of India and Mongolia refused to pay their tax debts on the grounds that they were diplomatic property. These taxes then became tax liens against the properties. Essentially, the City of New York now claimed that they held a stake in these private properties because taxation debt was owed to them.
The City of New York filed a state court suit to establish that their tax lien claims were valid. The defendants argued that these cases should be handled in federal court as the diplomats would hold immunity under the 1976 Foreign Sovereign Immunities Act, FSIA.
The FSIA is a domestic American law designed to protect the commercial activities of sovereign actors within the United States. However, there are several key exceptions that limit the immunity of these sovereign actors. It is important to note that the Foreign Sovereign Immunities Act is not a bilateral or multilateral treaty. It is a national law that affects foreign actors operating within the United States, which was unilaterally written and passed by the American Congress.
The district court disagreed with the defendant's claim that the case should be moved to federal court, citing an exception within the FSIA agreement that declared that a sovereign's immunity was withdrawn in cases where rights and immovable property situated within the United States are an issue.
So, does the FSIA protect a foreign government from a lawsuit to declare the validity of tax liens against property that they own?
The court held that no, the FSIA did not protect India and Mongolia from this lawsuit. A lawful exception did exist within the international agreement that suspended their immunity in this regard. Under the FSIA, a tax lien is defined as a claim against the property of another in order to secure the payment of debt. New York law defines tax lien in accordance with the FSIA's definition.
This means that the City of New York was trying to validate its rights to the property owned by the Indian and Mongolian governments. Because any such lien would change the stake that the City of New York and the Indian and Mongolian governments had on these properties, rights and immovable property situated within the United States were being evaluated. Thus, the exception criteria was met and the diplomatic immunity granted under the FSIA was suspended.
This case demonstrates that a state court can, in fact, prosecute a sovereign entity if a specific clause within the FSIA agreement provides them with an exception that supersedes diplomatic immunity. The exception, found within U.S. Code section 1605, subsection A, paragraph 4, suspends the immunity that the sovereign, in this case India and Mongolia, holds over their property in relation to paying property taxes. While India and Mongolia would be immune from eviction and forced payments of their debts, a validation in a New York City court would prove that the debts had lawfully become liens and could lead to the money owed resurfacing in negotiations between the United States, India, and Mongolia.
The court's decision was verified by looking at Alfred Dunhill of London Incorporated versus Republic of Cuba. This judgment established a separation between sovereign or public acts of a state and private or commercial acts. The 1969 Vienna Convention did not expressly address the issue of domestic tax liens on diplomatic property and thus did not influence the court's decision.
The scope of the FSIA agreement highlights that sovereign entities are subject to American commercial regulations where domestic law provides room for doing so. More generally, this case demonstrates that domestic law can, in fact, confine the commercial relations of foreign states operating within a particular nation.